Well, oh, can you see my screen?
Yes.
Okay, great. And is it the right screen? It's not looking right on my side.
Navigating rights.
Okay, good. All right. Well, welcome everyone. My name is Connie Pascal. It is a pleasure to have you join us tonight, where we are welcoming Nancy Chronic to our colloquium stage to kind of update us on a colloquium that Nancy gave us back in April. This is again updated on navigating rights, liabilities, and challenges in a shifting legal landscape. And let me move forward. Again, that's a little bit, that was the flyer that went out. So let me introduce Nancy. So Nancy Chronic is a teaching professor at Rutgers School of Communication Information, where she teaches courses on community engagement, information policy, and intellectual freedom. She holds a Master of Arts degree in library science and a Bachelor's of Arts in anthropology. I didn't realize that. I love anthropology. And also a Master's of Public Administration from New York University. We are it's not often that we get to have the past president of the American Library Association with us, but Nancy served as president from 2000 to 2001. She also led the ALA's Right to Know Information Commons and civic engagement programs, and she established the James Madison Award, recognizing champions of public access to information. Nancy has testified before Congress. She's appeared on platforms like The Today Show, NPR, C-SPAN, and received more awards than we can count, including the ALA Ken Haycock Award for promoting librarianship. And because she does keep it real, she actively serves as the board of trustees of the Highland Park Public Library and is on the editorial board of Library Quarterly. So Nancy's career has had a lasting impact on public access to information and the role of libraries in democracy. And we are so happy to have you join us, Nancy. So whenever you're ready, go ahead and start your presentation.
Well, thank you. And I'm delighted. I hope some of my students are here. If we can talk afterwards, but I have to show you my t-shirt. So
Very nice. I'm with the band,
I stand with
Banned.
the band.
That's
Pictures of
so
lots
good.
of, yeah. So I don't get to wear it often enough, but I thought tonight is my night.
It
So
looks good. It looks
yeah,
good.
thanks. I'm going to share my screen. So let's hope that we get it right here. Let's see, desktop one.
I
Um,
see it. Yeah, we just need to go to full screen.
okay. So slideshow. And whoops.
You go to slideshow and then current. There you go. Current screen.
Uh,
Or you can go down to the very bottom. There you go.
Okay. So we're good?
Yep.
Okay. So I want to thank Connie for inviting me back and say how delighted I am to join everyone tonight. I ran the colloquium years ago, and I think it's one of the best things we do, and I love to participate at any level. So thank you for having me back. But I will tell you, when Connie approached me about doing a 1 hour session on legal rights, I was stunned. I thought, oh my goodness, how could anybody do 1 hour? I do all courses, full courses, and I can barely get to all the topics. But I said, okay, I'll give it a try. So tonight, I'm going to give you a quick overview of this vast topic, and I'm going to begin with a story. I think storytelling is a really powerful way to talk about what we do, and hopefully, by bringing it to you in a story, you can digest a very complex topic. So I'm going to use that story as a backdrop, for discussing rights and challenges in this shifting legal landscape we're in. And I got to tell you, it's shifting every day. We used to think we had precedent, but I don't think that we can stand still for a moment and think that we understand where we're going, because it can change at any moment. So, as you have probably picked up or didn't think about in the introduction, I am not a lawyer. So I am not prepared to give you legal advice. But I do teach courses like intellectual freedom and information policy here at Rutgers. And they're the source of many of my thoughts about this broad and challenging topic. And hopefully, you will see that this is not just legalese we're going to be talking about. We're talking about real life experiences and how we, as people in information related professions, can start to think about some of these so-called rights that we assume we have, but they're not always as clear as we think. So here's a picture of my library's grand opening last November, Highland Park Public Library. And we opened with great fanfare, not only after a renovation grant, which we were thrilled to have, but we were closed for almost 2 years with COVID. We reopened, and then we had a Hurricane Ida flood. We were closed almost another year, and then we got notified we got a renovation grant. So then we closed for a lot longer than we thought, almost a year and a half. So we were thrilled to come back, but we didn't know what would happen. And it was very exciting to be here. The woman in the front is our mayor of our town. The state librarian is on your right. Our library director is the second person in behind a little on the left, and other trustees, but also officials from not only our local town, but the state assembly. So it was a big deal. We didn't know if it was going to be well attended. We had 1,500 people show up. You could barely get in the building, and you could not get into the room where we were doing the speeches. So it was just a very exciting event for all of us and a real tribute to how important libraries are. So reopening meant we were ready to finally welcome back community members into our building, and lots of others. Among them, this guy. He's now officially a book banner. So this all happened last January and into more recent times. So this happened in the last year in a town like Highland Park, not where you'd expect to have book bans. So just 2 months after we reopened the library, this very disruptive and notorious, locally notorious at least, patron named Christo visited the library, initially objecting to the young adult award-winning LGBTQ book, Genderqueer. This book, if you're not familiar with it, is on the top of almost all of our most banned lists and has caused a lot of trouble for several librarians here in New Jersey, as well as across the country. Staff at our library courteously made the library's selection policy and reconsideration form available to him when he complained. And he refused, though, to provide his name and home address or provide other details represented on the form. Days later, he comes back to the library with another man filming the staff and objecting to a second LGBTQ book. This book is gay, claiming that the book was shelved in the children's room where it was not. And then they took this video that they had shot while they were interacting with library staff. And they not only shared it on a website where Mr. Christo makes money from his, but then they took their complaint to our town council. And so they went and they read a portion of one of the books. And you can imagine, if you just read a passage from any book, somebody who's not familiar with the book as a whole might be quite surprised. And in fact, the borough council members were quite surprised. Now, this group, the two of them, they also use the New Jersey Freedom of Information Law, OPRA, as it's abbreviated, to request a list of library staff members and their home addresses from the town administrator. In February, in concern that they were going to show up at our board meeting, and I might say it was my first board meeting as president of the board, library staff alerted community members, and they only had a few hours to do it, but they did try to make sure that the challengers had people from the community responding. So this challenger named Christo, he calls himself a First Amendment auditor and a citizen journalist. And he has filed claims against nearby communities alleging violations of his First Amendment rights. This is the first time he did it against a library, but he's very notorious, particularly in Edison, where he used to go to the board meetings like every month. He operates several news-related social media pages and posted this encounter, as I mentioned, on it so that people who went and looked at it could also ensure that he was making money off of this venture of his. So, the Open Public Records Act is something he uses a lot to expose what he views as ethics violations and illegalities. You can imagine now what that means. So now keep in mind, these books are written for young adults. They were shelved in the young adult section of the library, and they have won many awards and shown up on best book lists. So these were chosen with criteria that we developed in the library, but we rely on experts to recommend books, and these books were highly recommended. So I use this example of the challenge to young adult books at the Highland Park Public Library, not to spend the day talking or the night talking specifically about banned books so much as because they appeared as what appeared as a fairly straightforward book challenge incident in our library raised a variety of rights issues, demonstrating the challenging legal environment within which information and other public institutions operate. So I'm giving it to you as a case study, not just a banned book report here. So on the surface, I counted at least 9 legal or other liabilities connected to this close encounter with a so-called book banner. So before I get into what some of these rights are that we feel that were challenged, I think it's really important to think about what do we mean when we say a right? So a right is something that's a justified claim on others. It can be a moral right, like life, liberty, and the pursuit of happiness, for example, or a legal authority, or both. All rights are not necessarily cast in law, but it's to possess, claim, and use a thing as one's own. So you have a right to something. Women's rights, gay rights. I'm sure you can think of lots and lots of different rights. Freedom to read, the right to read, etc. Our First Amendment rights. We talk about rights all the time. But what do we mean by those rights? Well, we can talk about rights in lots of different ways, but I like to explain them, particularly when I'm talking about the First Amendment of the US Constitution, the difference between negative rights and positive rights. So here's the first claim we could make based on the encounter with Christo at the Highland Park Public Library. It prompts me to ask you, do we really have free speech rights in the United States? Good question, especially since we're getting challenges to them all the time. So let's remember that what the First Amendment states. It states that Congress shall make no law abridging the freedom of speech. Now, this is a negative right. It's what Congress should not do, cannot do. It states what we think of as our free speech rights, but it actually is just saying what Congress cannot do to us. So this text does not precisely define the boundaries of our free speech rights at all. Instead, we leave it to the courts to interpret the meaning of freedom of speech in the United States. Our judicial system only resolves cases and controversies after an alleged denial of rights occurs, which is another sort of interesting way to think about this. So, and then it establishes precedent for later cases. So their decisions often include rules, regulations, and guidelines. In short, though, free speech rights remain only as secure as we make them. So we have to challenge a sense that our rights have been violated. We don't automatically get them protected. Courts leave the capacity to enforce our free speech rights, at least we think they do. So in contrast, whoops, sorry, I got a little bit taken away here. Wait a minute. Oh dear.
Nancy, I have your presentation, remember, in case you need it.
Now, can you still see it?
We're seeing your a blank presentation at this point.
Oh, okay. Hold on. Let me see if I can bring it back up. That's the first time that has ever happened to me, but no, these things happen.
There you go. Okay.
Oh, sorry. Okay. So when I was going to tell you our positive rights, then suddenly, yeah. Okay.
There we go.
Oh.
Yeah. If you can go to full screen.
Yeah.
Excellent. Yep. You're good. Thanks. No problem.
There's always got to be one glitch.
For us, there does. Yes.
Yes. Okay. Oh,
okay.
Yeah. Wow. That was weird. Anyway. Okay. So I was telling you about negative rights. So now we're going to skip into positive rights. So in contrast to our First Amendment, we have Article 19 of the International Declaration of Human Rights, which states that everyone has the right to freedom of opinion and expression. This right includes the right to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. This is an example then of a positive right, and you can see it's real different from the very simple statement in the First Amendment of the Bill of Rights of the United States Constitution. Yet this free speech rights claim has no power of enforcement, and as such remains an aspirational or moral right. So internationally, we've declared we have these rights, but it's really the First Amendment of the United States, which is a negative right, that really does give us, actually protect us more than this so-called positive right that spells out what it is, but in fact makes it very difficult to enforce. So in addition, so how do we go from what Congress cannot do to abridge our free speech rights to ensuring young adults in Highland Park the freedom to read those two books that got challenged, for example? So in 1973, the Board of Education versus PICO book banning case, which is a case in Island Trees, New York, where the school board was challenged by a man named Stephen Pico. It went all the way to the Supreme Court, this case, and the court not only ruled that the books had to be left on the shelf in the library, but that students have a right to receive information under the First Amendment, claiming the right to receive ideas is a necessary predicate to the recipient's meaningful exercise of his own rights of speech, press, and political freedom. So that's what, when the court interprets, it can make some pretty affirming statements. And that's a very powerful statement that we not only have the freedom of speech as a right, but with that comes the right to receive ideas, which is very much what libraries and other institutions, like higher education institutions, are involved in. So it's worth noting, unfortunately, we have a pending case that went through the Fifth Circuit in New Orleans, pending if the Supreme Court accepts it, challenging this right to receive information through libraries. So it's a pretty important right for us to ensure. So having it on the chopping block is pretty dangerous right now. So we go from a negative right of what Congress or other public bodies, that was extended to all public bodies, so a local government, a state government, as well as the federal government, cannot do, to creating a positive right to receive ideas while denying the right of a school board to remove books simply because they don't like what those books have to say. So another thing to know about the hierarchy of classes of speech when we're talking about this idea of free speech in the First Amendment. So is to ask the question, are these free speech rights absolute? Do we have, can we say anything and do anything with impunity? So the answer is no, but the court itself creates rules for determining just how constitutional our rights are. And this is not just true for the First Amendment, it's true for lots of different rights that are included in our Bill of Rights and beyond. So here I outline the court's hierarchy of classes of speech. So the first class is often referred to as strict scrutiny. That's high value speech, including political speech, which in the United States is particularly important to protect, and which merits no restrictions. In contrast, intermediate value speech merits few restrictions as well, but includes such categories of speech as advertising and indecent expression. And then finally, we have low value speech, which merits restriction with minimal judicial scrutiny. In other words, attempts to regulate this class of speech are generally permitted, not only in narrow categories such as obscenity, child pornography, and hate speech. And those areas are highly contested in our world online, in libraries, in bookstores, and elsewhere. So it sounds pretty straightforward, but it is not. So how would the Supreme Court view Christou's contention that genderqueer is obscene? That's what he said it was. So in 1973, which was actually a pretty important year for free speech cases, the court developed a test to determine whether speech is obscene. And that was in a case that was brought by a person named Miller. So it's famously called the Miller test. It includes 3 parts, and they must all apply. The average person must find the work taken as a whole appeals to the prurient interest. And I can't stress enough that concept of taken as a whole, because you have to look at the whole work. You can't just read a passage, offend somebody, or read a swear word in a book and say that, or see one picture that offends you. It has to be the work as a whole, and it must appeal to the prurient interest. The second is the work depicts or describes in a patently offensive way sexual conduct or excretory functions specifically defined by applicable state law. And then the third is the work taken as a whole again lacks serious literary, artistic, political, or scientific value. So these tests only a judge or jury can use to declare a work obscene after considering evidence presented as part of a criminal or civil trial, not by a challenger who shows up at the library's front door one day. Generally, US law treats an expressive work as constitutionally protected expression until it is determined to be obscene by a judge or jury. So, sex, nudity, profanity, or references to gender identity or sexual orientation are not enough to make a work legally obscene under the Miller standard, at least not for adult materials. But per the Supreme Court, the literary, artistic, and scientific value of material does not vary from community to community. They talk about a community standard. By that, they mean, though, the full country, not, is it a standard in Highland Park versus Edison, etc. So, as long as material has what they call serious value, the First Amendment protects it, even if a small minority of the population finds value in a work. A reasonable person, as they call it, may not still conclude that the work has value for those readers and thus will be protected expression under the First Amendment. So what happens with minors' rights? Minors meaning young people under the age usually of 18, although states vary in what age what the age cutoff is to be a minor. When it comes to free speech, is it okay for them to read books like Genderqueer with passages that some, like Christo, find obscene? The Supreme Court has long recognized that minors enjoy some degree of First Amendment protection. So in 1969, they determined in Tinker versus Des Moines School District that students who were expelled after they wore Black armbands to school in symbolic protest of the Vietnam War had certain rights. They considered their First Amendment rights, and they said that these rights do not, or that students do not shed their constitutional rights at the schoolhouse gate, and that the First Amendment protects public school students' right to express political and social views. This was a really important development. Unfortunately, like in much law, you have these breakthrough kinds of cases like Tinker, and then over time, they tend to get whittled down. But this set quite the precedent. And it said that young people have rights too. The schools may have certain rights as well, but the schools have to honor the fact that students do have rights. So, like the subsequent Pico case that I mentioned before, the court declared that young people had the right to receive information, but it also limited minors' rights by giving public schools latitude to restrict receipt of information deemed, quote, educationally suitable or, quote, pervasively vulgar. Now, states may deem certain materials obscene for minors, even if they are protected for adults. So in my intellectual freedom course this week, we looked at minors' rights, and different states say different things about it. So the states are weighing in on this constitutional protection. So to determine whether young adults, like those in Highland Park, can claim the right to read a book like Genderqueer and other similar books, the Supreme Court, which recognized minors' free speech rights in that Tinker case and several other cases like Ginsburg versus New York, that states may deem certain materials obscene for minors, even if the materials are protected for adults. So this makes these rights a little bit more cloudy here. Accordingly, though, most states have enacted so-called harmful to minors statutes. Um, and the harmful to minors or obscene as to minors test parallels the obscenity test set forth in the Miller test. But the considerations are in the context of offensiveness and serious value for minors. So we've got the same tests, but they sort of look at the context as being age appropriate. So again, the material must be examined as a whole. And as we said, Christo only pulled out a few passages that he found offensive. The material must be viewed from the perspective of the oldest of minors. That means 17-year-old minors. So just because you're minor doesn't mean you judge the material on the basis of a 6-year-old just learning to read, but you judge it on the basis of the oldest minor. And if material is protected for a 17-year-old, it is protected for all minors. So only a court, as just with adult materials, only a court can determine that material is harmful to minors. The court that has determined that either the books challenged are either harmful to minors or obscene has not happened. And this book has been challenged many times, and these two books. And so far, so good. Courts have not judged them to be obscene or even to be offensive and not have serious value for minors. Now, in New Jersey, lawmakers were eager to deter exposure of obscene materials to minors, and they adopted a law that makes it a third-degree crime punishable by years in prison to sell, distribute, or exhibit obscene materials to someone under 18 years of age. Now, this kind of harmful to minors law it's available or has been passed in almost every state. And they follow it, but it's generally for the marketplace and has not been applied uniformly to libraries. Usually libraries are immune from liability. Whoops. Wait a minute. My arrow is what seems to be giving me troubles here. Sorry about that. Okay. So what about keeping the two books then in the young adult section of the library? Do we have a right as young people to be able to see that book, or do we have to go into the adult section? Well, the courts have determined that these books need to be considered based on what is age appropriate. So, as I mentioned before, these books were written for young adults. So they were placed in an age-appropriate area, contrary to what Christo said they were in the children's room, but that was not true. But here we have a case that was actually judged on the basis of can you so-called censor books by moving the books from, say, the children's room, because you think, well, the books are not offensive to adults, but some people find them offensive for children. So the courts ruled against libraries moving such titles, which sounds like an easy thing to do. Well, you don't like in the children's room, well, we'll just put it in either young adult or the adult section of the library. But in fact, in this case, two books, Heather Has Two Mommies and Daddy's Roommate, the community wanted to remove from the children's room and have the parents in the community have a right to decide where the book should be. And the court said, no, you don't have the right to do that. And they said basically that it's censorship if you move it from the age appropriate area where it was first, where it sits, like in the children's room for these two books, or in the young adult area for the two books in question. So those of you who are not familiar with Daddy's Roommate or Heather Has Two Mommies, they were the two books of the 90s that had people challenging here, there, and everywhere, and made Sarah Palin, who you may remember, famous when she, as mayor of Wasilla, Alaska, tried to ban them in her library. So this brings up the issue of parental rights. And this is another highly contested arena that we are seeing happen all around the country. Who has the right to decide what your children should read? So decisions are suitable for of what materials are suitable for particular children can only be made by the people who know them best, parents or guardians. So even librarians don't know your children best, or school teachers. It's really up to parents. Parents know what's best for their children, and parents are responsible for supervising their children, but not deciding for other people's children what children will read. And that's where this gets really sticky. So many parents that find that they don't like books and want to challenge them, they have a right to tell their child not to read the book. And we encourage them to get involved in their children's reading, but they don't have a right to then deny that book to everybody else's children. So, librarians, teachers, school, and library boards cannot assume the role of parents, or that what we call in loco parentis. That's really not up to us. It's a decision between parents and their children, or guardians and their children. Libraries can help. We give guidance. We suggest reading lists. We select books thinking that, or recognizing what our community and our children in the community might like, but it's still up to parents to decide. But this issue of parental rights has become highly contested, with some like groups like Moms for Liberty saying, we're parents, we don't want these books for any children in our community. And that's just not fair. It's fine for them to say it for their own children, but not other people's children. Okay, so what's happened? Well, I'm sure it's no secret to anybody that we have had this skyrocketing number of book ban attempts around the country. So Highland Park, New Jersey, we've not had too many in the past, but we, like so many other communities in New Jersey and beyond, have seen a lot more book ban, book challenges arising. Several states now have passed laws to suppress access to books in schools and libraries, often under the guise of what they call parental rights. So far, the courts have not supported most of these laws, but they decide these cases so slowly. So in the meantime, what will these institutions do when the books, when they need to comply with state laws until the courts rule? So here is a map showing many of the restrictive book laws that have been passed. Now, this map is a year old, and I hate to say it, but there's more pink, but there's also a lot more green. Now, the pink states are ones that have enacted book ban laws, but the green states are the ones that have enacted protecting laws, freedom to read laws. And I'm really pleased to say that New Jersey is one of them now, Connecticut, Rhode Island, Maryland. So a lot of states are deciding that they now need to protect the right to read in their community. So, but it really depends then on on which state you live in, which is certainly not what the amendments to the Bill of Rights was supposed to mean. So, and in some of these states, we're seeing liability of for librarians. They can be charged with claims of criminal obscenity, and they could potentially go to jail for purchasing books that may be very of great interest to people in their community, young people in their community, but some in their community may decide that's not true and charge them. So, this exception of specific state laws created to allow for suits against the government in a particular context. So, in most states, public institutions are immune from tort claims, but these certain states have actually changed their laws to make the not only banning books for minors, but also holding librarians legally accountable. Not just librarians, but people who run bookstores, websites, etc. And they could face criminal charges if they distribute what some consider indecent materials to minors. If a community member just if a community member dislikes the content of a book on the shelf. Remember, it was supposed to be decided by a court of law, not a community member. So the books caught in the crosshairs of obscenity challenges include award-winning authors like Margaret Atwood, F. Scott Fitzgerald, and others. Groups like Moms for Liberty have gone after books about seahorses, even for being obscene, as well as books about Johnny Appleseed and hurricanes. So they might go after the same books that they went after in Highland Park, but they're putting on the list even Winnie the Pooh, which was called into question in one community for not wearing pants. So that means librarians could potentially go to jail over Winnie the Pooh. So we talked about all kinds of issues related to the First Amendment, but there's another piece to this that came up in this challenge in Highland Park, and that's the right to do what we call a First Amendment audit. So these auditors typically film or photograph in public spaces like town halls, libraries, police stations, or parking lots. And then they take their recordings, they post them online, and they some of the opponents of these refer to these auditors as frauditors. I mean, it's really pretty fraudulent, but it is legal. So these audits record interactions with public officials or in public spaces to test and document the right to freedom of speech in the press, and often posted online to promote transparency and open government. But do they really do that? Well, that's what they're saying they're doing. Generally, they're protected under the First Amendment, though, and the guarantee of freedom of speech in the press. Auditors believe these audits promote transparency and government accountability. So, do you believe that? Do you think that that's a way to make government more accountable? Well, certainly, if a community or a government is doing certain things, yes, it's like policemen wearing some kind of videotaping device. So, yes, it is a way to make government more accountable. But critics argue that some audit tactics can be confrontational or even harassing. And I will tell you, it was not comfortable having this event videotaped when these challengers came to the Highland Park Public Library. But I will say that they were ready and prepared from their good training, and they treated the auditors very respectfully. So they didn't have a whole lot to accuse us of, but they did post it. So another right that came up from this single event is the right to privacy. So a lot of us consider that we have a right to privacy in our country. But like the First Amendment, there's only one amendment even in the Constitution that sort of talks about privacy. But it's the Fourth Amendment, and it's another one of these negative rights. It protects individuals in their persons, homes, papers, and effects from unreasonable searches and seizures by the government. There is no mention of privacy, though, in either the amendment or anywhere in the whole Constitution. In contrast, we have, like we did with the First Amendment, an article of the United Nations Declaration of Human Rights, Article 12, that spells out this positive right of privacy. No one shall be subjected to arbitrary interference with his privacy, family, home, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attacks. But how would this right be guaranteed and protected? So here we have in Highland Park these guys coming in and filming people using the library. One would think, even though they're in a public place, they should be entitled to protection. And the same with even, filming the staff and their interactions. So although the Constitution does not explicitly reference the word privacy, the Supreme Court has ruled in, just like it has many times under the First Amendment, inferring a right to privacy from various portions of the Bill of Rights. And we've had lots of common law as Congress and many state legislatures have passed statutes. And as far as libraries go, we've got the library confidentiality law in every state of the union. So we could ask, should these First Amendment auditors have had the right to learn personal information about library employees through Freedom of Information Act requests? Note, fortunately, our town administrator gave them the names as something that is a publicly available piece of information, but refused to turn over home addresses for our library staff. Imagine if anybody could request that, and the kinds of behaviors that we're seeing of people trying to search people down when they disagree with them now. Even, judges have been murdered or their children murdered, etc., because this information gets out. And here in New Jersey, our newly elected governor, somebody got a hold of her private information and gave out her personal information, even though it was illegal. So so we have these privacy rights that we need to protect. And should these auditors have been permitted to post their recordings publicly on the internet, featuring library users and staff who never granted them permission? So despite the Constitution lacking a privacy clause, we do have laws in this country, including the Privacy Act of 1974, with the purpose that states the right to privacy is a personal and fundamental right protected by the Constitution of the United States. So in addition to protecting federal records, the Privacy Act also includes something called fair information practices that guide organizations and businesses in developing their own privacy policies. And in the case of libraries, many of them have their own privacy policies, as we do in Highland Park. And we also have a policy that spells out the terms for filming people when they come in the library. So we have protections, but how good are they? Well, we have to protect ourselves. So one other area that comes up is something called the public forum doctrine. And this is
Nancy, I just want to jump in here real quick and give you your 10-minute warning.
okay, thanks. So we will just get into this right quickly, one more, and then we'll wrap up. So the public forum doctrine. Thanks, Connie, by the way. So did the library have the authority to promulgate and enforce rules governing the use of its facilities that could have resulted not only in a disciplinary action against these challengers who simply claimed they were exercising their First Amendment rights, but also to determine what information they could have access to? So libraries, like many other institutions, are subject to something called the public forum doctrine. As limited public forums, public institutions like libraries can only create time, place, and manner restrictions to carry out their missions under the First Amendment. But these restrictions must be content neutral. So that gives us a right to determine what kind of behavior we accept as long as it's not content related. So, oops, wait a minute. Sorry, my arrow is going crazy again. It's going backwards. This is weird. Sorry. So we will catch up. So let me try it on my other screen. Okay. So we were talking about the right to privacy and the public forum doctrine, and the other item I will add, which I put on my list of rights that could be raised in this context of this event, was copyright. Is who really owns the information that these people were trying to share and make money off of. Usually copyrights are related to not only who owns the information, but who profits from that information. So one last thing to mention is that part of the responsibility of our rights is to protect all people, and that means the whole purpose of the Bill of Rights is to protect the minority from the tyranny of the majority. So that means we can protect one person's right to read a book if they so deem it of interest, against many others who think that right should not be allowed. So we must remain ever vigilant and make sure that the work we do really does protect everyone's rights and not just the rights of the majority. So that's exactly what happened at Highland Park. We had people show up for our meeting to stand up for their rights, to stand for the band. And you can see here a few of the comments that we got. It was overwhelmingly positive statements about the important role of the library protecting people's rights. So Chelsea said, thanked the library for providing materials for youth that provide windows and mirrors into the experiences of others and hopes this will continue. Jorge said he proposed the principle that no one has the right to tell anyone what we or our children should read, and noted the library is everyone in this room. So overwhelmingly, even though we had challengers, our residents, people from our community, stood up and said that they wanted to protect those very important rights. So in closing, let me tell you that you can declare your community a book sanctuary, as we did in Highland Park, to make sure you have safe space, and you are also now protected under our new state law to protect these materials. That doesn't mean you're home free, but that does mean at least the state has come forward to say that these kinds of rights are important to the citizens of New Jersey and citizens of many states around the country, and we're not going to subject them to the kind of censorship attempts that we've been seeing in states like Texas and Florida, Arkansas, and Iowa. So the legal survival guide is navigate your rights, know your rights, and you can start by having participated in this event. You can respond to controversies through active public relations and ongoing public education programs. That's really important to educate your community. And the community is really able to understand this. In every community where we've organized pushback, where there's been challenges, the citizens have stand firm and very convincingly. You want to make sure you have strong local relationships, take a stand in the courts and also in the court of public opinion. It's up to all of us to talk about and make clear what these rights are. And hopefully you will join the many advocacy groups out there that are galvanizing public support for the freedom to read, the right to read. So I've given you several books and other materials for bibliography if you want to learn more. And I look forward to hearing from you what your questions might be or thoughts. Thank you.
Well, Nancy, thank you. That was amazing, and it makes me so grateful to live in New Jersey.
Yeah.
Yeah. Well, again, we'll open it up. We have a little bit of time for questions. So if anyone has a question, please feel free to either put it in the chat and I'll ask it for you, or you can take yourself off mute and ask it. But while we're waiting for that, so so I got a question. So what do you think is the most important thing, like the one thing a future librarian or a librarian should remember when dealing with book challenges? You know, what's
What's
that one?
thing?
Yeah. Yeah.
That the library community has developed all kinds of guidance on the best way to handle this. It starts with good policy that your library board and your director need to make sure is up to date and in place with reconsideration. But also, there's lots of help out there. We have a fast action group. They called me when they heard this was happening in my library.
Mm-hmm.
And we have them in New Jersey, but we've got lots of help throughout the country.
That's great advice.
Don't act on your own. There's lots of help out there because they want us to trip up. And you could tell people like Christo, they are there to sort of put us on the spot and put us on the defensive. When we're prepared, we can get through this without any trouble. And we really
that's great to hear.
Our staff was well rehearsed. They knew exactly what their rights were and what they should and shouldn't do. And so it works out fine.
Again, just have to stand up and say something and not let the bullies push you around.
That's right. But be courteous. And, one of the most important things to do is listen.
Right. I was just going to say, we do have to be empathetic to other points of view.
That's right.
And even though they're misplaced and often feel really bad, it is good to lead with empathy, even for people who are doing hateful things.
Absolutely. And we put together not only good policies, but good processes of what happens. You go through due process, you reconsider the book, and you have a panel to do that. I mean, you depend on a variety of opinions to either reinforce, or sometimes the book does need to be withdrawn, perhaps. But librarians, if they're really careful about what they choose to begin with, now, that doesn't mean they shouldn't try to press the envelope sometimes.
Right.
But they want to make sure that what they buy really responds to community needs.
Well, thank you again for reinforcing all of that and for helping us, again, navigating a very challenging time as library and information science professionals. So, again, thank you all for joining us, and we'll stick around for a few minutes in case anybody would like to ask a question. I will turn off the recording, so if you'd like to do that. But again, thanks again, Nancy. Just really, really good stuff. And we appreciate you taking the time to spend your evening with us as well.
Thank you. And sorry about some of my computer problems.
You should never apologize for any of that.